And with that, it's my distinct pleasure to welcome and introduce our next speaker, Attorney Andrew Hyams. He is a lawyer based in Wellesley, Massachusetts. He has represented close to 400 physicians, nurses, and other health professionals defending board complaints in hospital peer review matters and in applying for their licenses. Counselor Hyams graduated from Harvard Law School and holds a master's in public health from Harvard School of Public Health. He is a former Board of Medicine General Counsel, and he represented the physicians in the 2015 Supreme Judicial Court case reversing 20 years of Board of Medicine practice, establishing that a summary suspension must be supported by a preponderance of the evidence, not just substantial evidence. And it's our pleasure to have Counselor Hyams today presenting on the Board of Registration in Medicine and Risk Management and Avoidance. So thank you, Counselor. I look forward to your presentation today.
Thank you. Good afternoon. And we're going to talk about the Board of Medicine, but first, I want to recognize the Mass Psych Society's loss of Jim Hilliard, who was Jim was a legal giant. He was a superb lawyer, and he was so kind. He was so generous with his time. He was a teacher to both the medical profession, and he was, from my perspective, he was a great teacher to other lawyers. A tremendous loss. I've got no good segue from Jim to the Board of Medicine, so we'll just get to work. The usual caveat: this is not legal advice. You're not a client. There are a couple of clients out there. Don't worry, the meter's not running. The other note I want to make for you is the handout is it's high density, and it's got both the topic headings and it's got the meat. And hold on to that. I worked hard to have it so that you'd have really this, the substance of this. If you got to take the dog for a walk for a minute or anything, you won't miss the meat. It's in the handout. We just have a few relevant slides. Otherwise, you're stuck looking at me and not slides today. So the Board of Registration in Medicine. You all want to avoid the Board of Medicine, but the problem is their ever expanding authority. Risk management that's all encompassing for you to avoid the Board of Medicine is not possible. And that's because the board's authority is so broad. The board regulates your practice of medicine. Everybody understands that, but it's the board's regulation of the practice of medicine is far, far broader than just malpractice. Tom went over the 4 Ds: dereliction, duty, direct causation, and damages. In law school, I learned it as duty, breach, causation, damages, and that's the malpractice standard. For the board, they don't have to prove causation. They don't have to prove damages. It's a much easier case for them. All they have to prove is duty and breach of that duty. Cases that malpractice lawyers would laugh at, the board is thrilled to take. Whether you caused harm or not, it's irrelevant. Whether there were damages or not, it's irrelevant. The board is going to be interested if it gets its hands on that case. The board's regulation of the practice of the medicine is super broad, but it does not stop there, because beyond that, the board the board regulates your, quote, your moral character. It can discipline you for something that undermines public confidence in the integrity of the profession. Let me repeat that, because it's mind-boggling. Anything you do that they can argue undermines confidence in the integrity of the profession in its judgment. All right, so this is regulation on steroids. If the practice of medicine is earth, your moral character and the public perception of integrity of the profession is the rest of the universe, and for the board, it's it's the Big Bang. It's the ever expanding universe. The board can chase you for any crime that it thinks you committed, whether or not you were convicted. So if there's an acquittal based on an unconstitutional search, that's fair game. If the common plea is something is continued out of the finding, a quaff, that's fair game too. A domestic dispute, between doctor and wife. I had this case. The wife called the police, falsely claimed on the phone that the husband hit her. The police show up. She tells the police that she was lying on the phone. He's arrested, spends the night in jail, is not prosecuted. That's still a board complaint. The board investigated that. An acquittal for leaving the scene of an accident. That's a board complaint. A fight with a neighbor over some nonsense, and not thinking it through, taking a plea on the advice of an attorney who has been hired to deal with a criminal case. That turns into board discipline. And I've heard the board, the chair of the board complaint committee, when argued on, this is a few years ago. Look, this is behavior that thousands of people engage in. It doesn't mean that they have bad moral character. This has been addressed. His response was, we hold doctors to a higher standard. They're historical artifacts, legal historical artifacts that explain how the board got to this point. The Supreme Judicial Court allowed the board, as it should have, to discipline physicians who committed crimes. A physician was years ago was convicted of Medicaid fraud, and argued to the court that, well, Medicaid fraud is Medicaid fraud. It has nothing to do with the quality of the practice of medicine. And similar situation, of physician convicted of selling machine guns with silencers, and said that has nothing to do with the practice of medicine. And in very broad language, the SJC said the board can govern moral character. It can govern an act by a physician that undermines public confidence in the integrity of the profession. And the guy that sold machine guns, the guy that committed Medicaid fraud, you can take his license. Well, this is only the board's interpretation of its authority has, since over all these decades, it's only gone in one direction, beyond crime, beyond anything you can actually predict. And they're they're going after physicians for especially this area of undermining confidence in the integrity of the profession, in their opinion. All right. So, putting this in the realm of risk management, my telling you to practice medicine competently and to live, to lead your lives morally in the estimation of the Board of Medicine, that's not a good use of our time, because I could spend hours preaching how to be a good person, right? That's the risk. That's the risk management in its broadest terms for the Board of Medicine. But we can spend some time on how to handle board complaints. And then we'll talk about a few things that you can do to stay off of the board's radar, and some of the few things you can do to help things go well if the board comes knocking on your door. All right. So the very, very big picture at the board is that it investigates complaints. Second, it gives you a chance to respond. And third, if it doesn't like your response, it's going to bring formal public charges against you. All right, so we're going to talk about 1 and 2, dealing with public charges that the board has brought against you. That's another talk for another day. Complaints at the board. All right. My overview of the complaint process is there are two types of complaints. All right. The first type is type 1 is the minor complaint where you're just dealing with the consumer protection coordinator, and hopefully that's where it stays. All right. The type 2 complaint is a major complaint, and you're dealing with the prosecutors in the enforcement unit, and that's serious business. All right. Type 1 complaints, you're going to get one of those by certified mail from Paula Hannon, the consumer protection coordinator. And just as an aside, make sure the board always has your current address, because you want to get that complaint. If you're the last known address that you gave to the board is someplace you worked and you forgot to update your address, or you've moved, it's going to cause you needless heartburn when the complaint catches up to you and it's past 30 days. So always keep your address current with the board. The type 1 complaint is the good kind of complaint. It's good because the board has given you a copy of the complaint. And not to spoil the surprise, but with type 2 complaints, they almost never give you a copy of the complaint. And it's also good because you learned about the complaint in the mail, not because a board investigator called you trying to track you down and tried to ask you questions. Now, if you look at the, I've got ones for the first slide is the board complaint website, and you'll see from the board's website. Debbie, can you put that one up? Slide 1. Is that up? Oh, thank you. You'll see from their website that these complaints are very, very easy to file. The patient just goes online, and it's easier to file a complaint about you than it is to write a Yelp review, because they don't have to go through the hassle of opening an account and picking a password or anything like that. And I mean, the board in the language I highlighted there, they said the preferred method is to use our online complaint system. So, Tom Gutile's reference to, what causes malpractice cases, rage. Well, if there's rage, there's an immediate way to assuage that rage, and that's to go online and file a complaint. And there's none of the friction of having to print out something, get a stamp, go to the post office, which you'd find that if you put up slide 2, that's the Board of Overseers complaint website. Yeah, thanks. See, what I highlighted is because I really don't understand it. Because of the confidentiality requirements, complaints cannot be accepted via email. That's to me, that's legal mumbo jumbo. Why is there confidentiality dictating a result like this on the Board of Overseers website, but there's no such thing as confidentiality dictating the same kind of result on the Board of Registration Medicine's website. I mean, the point is that I'm glad for the purpose of complaints. I'm very happy I'm a lawyer, and you're a tremendous risk for these for being the target of complaints. So the complaint that the patient files usually has a release from the in the complaint, allowing you to disclose medical information about the patient in your response. And the complaint from the patient is usually unreasonable. Often it has lies. The board doesn't screen these complaints for plausibility, doesn't screen them for reasonableness. The board has received a complaint and it's passed it on to you. So what do you do? The first thing you do not do is do not respond. Do not respond hastily. You're going to get this complaint, and the temptation is to answer to yourself immediately because you're hoping a quick response means that there'll be a quick dismissal. But that's not how the board works. Even where the allegations are completely frivolous, no matter how quickly you respond, the board can take months and years to deal with this complaint. So I understand the complaint's causing you pain. You want to remove the source of pain. Resist that temptation. You could be living with this complaint for months and years. Hopefully you learn to compartmentalize it and do what's important in the meantime, which is practicing the best medicine that you can. All right. So the complaint is hanging there. A lawyer might be free. Right, you call your malpractice carrier because your malpractice carrier, your policy might pay for your defense, or the policy might pay for part of the defense. Depends on the policy. They might have a panel you need to use. They might have a limit on the contribution per hour. Most of them have a $25,000 limit on defending something at the board. The doctors that often, they forget that they've got coverage because they think the malpractice policy deals with medicine. But the first point I made in this was that the Board of Medicine deals with a lot more than medicine. And you get a complaint about something that has, the board has started something against it that has nothing to do with medicine. It's counterintuitive to call your malpractice carrier, but there are a lot of situations where the malpractice carrier is on the hook to defend you, even though the complaint has absolutely nothing to do with the medicine. All right, so whether you're covered or not, whether you've got coverage for a lawyer or not, obviously hire a lawyer. Hire a lawyer that's got experience at the Board of Medicine. Every state agency has got its quirks and traditions. those quirks and traditions are not often are not written, or more often than not, are not written down anywhere. So you find somebody with experience in the Mass Medical Society. I'm sure the Mass Psychiatric Society can help. There's a Mass Medical Society legal defense plan. A lot of ways to find lawyers. All right. Help your lawyer be efficient. All right. Even though the insurance company might be paying for your lawyer, you really need to be, and you think a $25,000 cap on the coverage is going to carry you through. It can go very fast, especially if you might need to hire an expert. Right? Help your lawyer out by writing out a narrative, nice, clean, as long as possible, brain dump of your narrative. Write out the story. It jogs your memory. It helps your lawyer fill in the gaps so you can fill them in. Point out the gaps so you can fill them in. Make sure you go through that exercise. All right, next. Obviously, preserve the medical record. Don't make any change to the medical record, even if you're going to sign it and date it and initial it, and it's you're making that change in a completely kosher way, where the change is there's no attempt to cover up or change without dating the change, right? I've asked doctors for medical records, and it shows up with all these, the medical record shows up with all these changes. And I said, why did you change it? And he said, I wanted to clarify it. And I said, well, maybe it didn't need to be clarified. Discuss it with me. Now we've got now we have a written record that, what am I going to do? White out the corrections and tell you to, let's go back. It's a mess. If you're going to make any changes, if you think anything's not clear, maybe there is something that we want to do, but wait and discuss it with your lawyer before making any change at all, before you number the pages, before you add a date, anything. All right. Beware of notifications. If you get a board complaint, you're subject to a board complaint. There are employer requirements. There are hospital bylaws that require, not all of them, but require that you notify the employer, notify the hospital that you are the recipient of a board complaint. It's not necessarily just renewing it when you renew your credentials that you have to report this kind of thing. So you might have an affirmative duty to report that you have a pending board complaint. All right. All right. So let's take a look at the board's cover letter. That's slide 3, and that's going to accompany the board complaint. All right, so just scroll down right to the middle there. You'll see that the board claims that it's inside Tom Gutile's circle of confidentiality. The board thinks that Tom's circle was correct. This is incorrect. All right, you'll see they say that the HIPAA provides that otherwise protected health information may be disclosed to a health oversight agency for activities that include disciplinary actions. And then they say the board clearly meets the definition of health oversight agency. All right, not so fast. This is inaccurate because under HIPAA, doctors are prevented from disclosing medical information when a state law is more protective of patient privacy than HIPAA. All right, and it goes back to an old chestnut of a case from the SJC in 1985, Alberts v. Devine, which established the physician's duty to keep the patient record confidential. That's a state confidential. That's a state law that provides more protection than HIPAA, and the board is skating around that with this letter. I've had this argument with them. They continue with this letter. It's fairly intimidating. I think it can get you in trouble with patients. It's true that very often the complaint will be accompanied by a release. If there's a release, that's fine, but often enough the complaint is not accompanied by a release. Often enough the complaint is from somebody who's not the patient. It's from a close relative. It's from a parent. The parent of somebody who's a patient who might be over 18, even if it's a complaint of from the parent of somebody who's 17. There are problems with that. Don't fall into, don't assume that because the board said it's okay to talk to them about the patient's medical information, that it really is okay for you to talk to the patient about medical and talk to the board about the patient's medical information. All right. So to sum up this privacy issue, make sure the patient has consented to your release of medical records. If the complaint is not from the patient, presume that there's no consent. And you're going to have a lawyer sort that out anyway. Don't be fooled by the board's complaint letter, the board's complaint cover letter. And that all said, even if there's no consent from the patient, sometimes I've come up with a generic response. It's possible to respond to somebody's complaints because they're of such a nature that you don't have to provide medical information in order to provide a meaningful response. So I wouldn't rule that out. It's not making mud pies. Each case is different. All right. So much for that. Next point. I'll put this bluntly. Do not lie to your lawyer. It happens. All right. When you speak to your lawyer, don't commit a sin of omission. All right. Your lawyer you lose credibility at the board, and it's almost worse that your lawyer loses credibility at the board. I mean, it's a complete train wreck to be caught in a lie to the board. All right. You tell your lawyer what happened. Give the lawyer a chance to dress it up. I had some really ugly stuff. I'll do my best. There are many the lawyers who defend doctors at the board. They're very skilled at this. They put the truth in a tux. They put it in a wedding dress. They serve lobster tails. They make it as nice as possible. Give us the truth. We'll work with it. I had a case where the doctor lied about something before she hired the lawyer. She lied about something to the board that was so inconsequential. It was almost like lying about spitting on the sidewalk. Nothing would have happened from her admitting to this issue, but the board figured out that she lied about it, and she was disciplined for lying to the board, not for what the original complaint was about. So don't let a nothing burger turn into a consent order because you were embarrassed about something and didn't want to rip the Band-Aid off. All right. Generally, responding to type 1 complaints, there's no formula. Like I said, there's no making mud pies. You always want to include, if you can. We're usually able to figure out that you can include a sentence that starts, I learned the following from this, right? So generally, you don't attack the patient. Admit that you're always engaging in continuous improvement. You need to understand that your patient is going to see the response. So you don't want to escalate the dispute with the patient by making a truthful but unnecessarily hurtful remark. Each case is different, but these are sort of, the general things on my checklist. I try, the doctor should say nice things about him or herself. There's a balance, you maintain your modesty, but if you've been volunteering, leadership positions, frontline COVID stuff, who you are as a person, who you are as a physician, that is relevant to answering the complaint. The flip side of that, and what I say not to do, is you don't go scorched earth. If your lawyer starts to sound like Roy Cohn, get a second opinion. I remember who that was. There are times when it does make sense to be aggressive with the board, but the goal is to get the complaint dismissed. So you don't make a legal point with the board if it's just going to be a little legal victory that has almost nothing to do with achieving that goal of getting the case dismissed. All right, you don't waste time trying to make sense of what the board is doing. All right, you go to the DMV and you get a line, and there are all these crazy lines there. You don't try to engage the shift supervisor and, why do you have this line? And, for one thing, why do you have that line for the other? You get on the line, right? So, and with the board, just, go, jump through the hoops. Don't look for an island of rationality in a sea of irrationality. You don't say to the board, that was a stupid question. Just answer the question. All right. So, all right. Next slide is the board's closing letter. Now we're still on type 1 complaints. This is a delight. All right. So type 1 complaints do not look for vindication. All right. This is what the board typically writes when it closes a complaint. We have decided not to recommend disciplinary action and close the complaint. However, information concerning this matter will be kept on the board. They kept on file at the board. We reserve the right to reopen this complaint should you commit any future violations of board statutes or regulations. All right. So as ominous as sounding as this is, I swear to you, this is an A+. This is the best outcome possible. I get this letter on behalf of the client, and I call them and say victory, right? And they get the letter and they're like, gee, this is kind of grim, but this is what victory looks like with a type 1 complaint. All right, so on to type 2 complaints. All right. Unless it was a type 1, you're not going to know that you have a type 2 complaint until something unpleasant happens. All right, a doctor will call me and tell me that they heard from a friendly lawyer at the hospital that the hospital received a subpoena for the doctor's credentialing records. Comes completely out of the blue, right? The doctor receives a subpoena for patient records. That's the first you're hearing of any problem with the board. You might receive a letter from the board with questions. Someone who works for you or someone who used to work for you leave you a phone message. Gee, the board called me. They asked, they want to interview me. All right. Or you get a call from a board investigator who says, I've got some questions. Do you mind answering the questions? All right. So, it's like, it's grim advice, but the investigator calls you, don't talk to him, don't talk to her. Be polite, this is already serious business. And to say, I'll be sure to get back to you. I just want to talk to an attorney first, get the information, and you get on the phone and you get an attorney. You can always talk later, but I've never seen anything good come from, that conversation that the doctor had with the investigator. I had a client who told the investigator, I've never had any problem with the law. I've never gotten so much of this as a speeding ticket. That's what the investigator reported that the doctor said. What the doctor says he said was that I haven't gotten the speeding ticket since the 1980s. Right? And the board, in bringing charges against this doctor, one of the charges was that he lied to board staff about whether or not he ever got a speeding ticket. This is, one of the several charges they brought against this doctor. It was nonsensical. He shouldn't have had that conversation. Never would have had that problem if he had not had that conversation. All right, so so I'm sorry, it's all bad news with the type 2 complaint. It's already gotten serious. The board enforcement staff is chasing after you. And this is not the consumer protection folks. This is the this is the board enforcement attorneys, the board enforcement investigators. They're very good. They're good at what they do. You might wish that you were dealing with the Keystone Cops. You're not. They're good lawyers. They have good legal tools, and they're thorough in their jobs. Now, the enforcement staff, we distinguish them from the board members. There's the board is 7 members, 5 physicians, 2 public members, and they're part-time. 2 of the members, it's usually a physician and a public member, comprise the complaint committee. And your type 2 case is being examined by the enforcement staff under the guidance of the complaint committee. Most of the work, all of the work is being done by the enforcement staff, and they're reporting to the complaint committee, and it's the complaint committee that ultimately makes the decision about whether you're going to be prosecuted. All right. The sources of type 2 complaints are peer reports. They could be it could be a report from an ex-wife, an ex-husband. It could be a malpractice award that's reported from the court. It could be the court that's reported a criminal matter, an OUI. It could be a patient if it was a very, very serious allegation. That's not too common, but it does happen that the patient allegation goes directly to a type 2. The board is the board with type 2 complaints is they're going to do a complete audit of your professional life. They're going to subpoena everything that they possibly can. They're going to go to all your former employers, subpoena records from your employment records, your credentialing records. They're going to check the criminal database. They're going to check MassPat. I had a physician, they checked all the local, they subpoenaed all the local pharmacies. It was for his records at the local pharmacies, right? And it was pretty. It became absurd. You know, they subpoenaed his local pharmacies, and that they found that he'd been ordering a huge number of a huge number of syringes. Excuse me, 90. You know, they said you're ordering 90 syringes a month. All right, explain that. And he says, I'm a diabetic. I'm taking insulin 3 times a day. You know, they were trying to tie this to some prescribing issues. You know, the board will dissect every one of your initial and your renewal applications looking for inconsistencies. So, you know, everything is up for grabs, and they're going to be, you know, they're going to be looking for anything and everything, and it doesn't have to have anything to do with a complaint. You can end up with charges being brought against you that have nothing to do with what was in the initial complaint. If the complaint is about quality of care, you're not going to see the medical records, right, unless you have them. And this goes to I can't emphasize enough the importance of having the medical record, right? So you need the medical record so that you can hire an expert before the board brings charges. The board's going to have the records, and they're going to hire an expert. And that expert opinion is going to go to the complaint committee. If you don't have the medical records, you can't get an expert to review them. So the complaint committee is only going to get one expert opinion, the opinion that's opposing you. Right. The board might let you look at medical records in their offices, but that doesn't help you if you need the expert, if you need the records for your own expert to review them. All right. So this goes to so this informs a very important principle of starting any job. All right. When you start work someplace, you're going to get a contract, and I look at these contracts, and one of the things that I insist that be put in the contract is that if the physician leaves that place of work, the physician will have access to patient records that where the patient is, you know, where there was a relationship with the patient. The physician will have access to those patient records if those records are the subject of any kind of regulatory complaint. If you don't have that in your employment contract, then you're at the mercy of the employer. If you left on bad terms, forget it. You're never going to see them. You hope you're leaving on good terms. You don't want the employer to start worrying about HIPAA and getting 3 or 4 opinions. It should be in your contract that you leave, you have access to the medical record, and you know, this is it's something that will that could be very, very critical to your preserving your license years down the road, when if and when there's ever a patient complaint. And there's no statute of limitations on there's no statute of limitations on the board's taking action. You know, there's none of this 3 years and you're okay. The board has a regulation on stale complaints and says that, you know, something is more than 7 years old, they have to show cause why they're going to go forward with it. But that's you know, that's that, you know, I see that as a regulation really for show only. They'll if they want to go after you for something that happened more than 7 years ago, they just have to come up with a reason for it, and they'll do it. All right. I want to leave time for questions, so I'm going to skip ahead to traps for the unwary. And during questions, I can come back to some of the points for dealing with type 2 complaints. That's worth skipping for now, because I'm hoping you will be guided by a lawyer through the whole type 2 process. All right. So, the risk management part of this, the traps for the unwary, staying off the board's radar. All right. So do what you can to shut down patient complaints. All right. Resolve billing disputes, even at a cost to you. Even if the cost is unreasonable, it's probably going to be worth it. All right. There were a lot of questions after Tom's during and after Tom's presentation about termination of the physician-patient relationship, and unless I was letting the dog out during this part of it, I'd add to that when you're arranging the soft landing, the conventional amount of time is 30 days. 30 days is pretty good. That's defensible. That's, that 30 days notice to the patient, find somebody else. I'd go more than that. I'd say 60, 90, make a record. It's something you can tell the board. Look, I understood that 30 days is conventional, but I wanted to give this patient extra time to find a reasonable alternative. I gave her 60. I gave him 90. I think it's definitely worth you doing that. All right. And you've heard from Denise. You've heard from Tom. Document. So I can just repeat it. Document. Contemporaneously document all prescribing decisions, all your compliance with MassPat. Document prescribing decisions where the patient resists appointments, doesn't, wants you to keep prescribing, but doesn't want to, the insurance ran out, doesn't want to pay for, additional appointments with you. Just keep document, because the board is only seeing things in two dimensions. If you haven't documented it to them, it didn't happen, right? Make a recording, make a record of demonstrating your humility. And what I mean by this is, in difficult situations, and this is just, as Tom said, get a consultation and make sure you document the consultation. If it turns out you were wrong, right, and things went south, especially, and if there's a patient complaint, you're providing to the Board of Medicine a record that you consulted with a colleague. It shows good faith, it shows earnestness, it shows sincerity. The complaint committee, when they interview you, they want to sniff out arrogance, and a record of getting a colleague's opinion is it's a good vaccination against for that. Right? Be careful on your renewal application. All right, don't. I've seen too many times that the doctor will delegate filling out the renewal application. Don't delegate it. Read each question very, very carefully. If you've had a traffic violation, don't assume that it's not reportable. Don't engage in wishful thinking. Don't assume the lawyer who represented you in the traffic issue knows how to answer the board question. Any gray area on your renewal application, get advice. Don't forget, the bar is set very, very low for discipline. The board can discipline you for conduct that has the capacity to deceive, even if you didn't intend to deceive the board. I mean, and that's from this Welter case that came down, just a couple of months ago. That again, if you engage in conduct that has the capacity to deceive, even if you didn't intend to deceive, the board can and they discipline Dr. Welter, and they'll discipline you. All right. So, and on your renewal application, don't wait until 3 days before your birthday to fill it out. Give yourself plenty of time in case you've got questions. All right. On criminal matters, any kind of criminal involvement, any arrest, anything like of that nature. All right. You've got a criminal lawyer involved. I hope. All right. But don't assume that the criminal lawyer knows what to do as far as the board's concerned. You need a lawyer watching your back in the criminal case, and you need a lawyer watching your back with the Board of Medicine. Could be the same lawyer, but it often is not. Right. The timing of criminal matters it's very critical because of the 2-year birthday renewal. It's conceivable that you can have a criminal case come and go within that 2 years. And what I mean by go is get it sealed under the new sealing statute. And the new sealing statute allows you to, on a professional license application, answer the question, do you have any criminal record? Any record of an arrest or anything like that. It allows you to answer the question no. It authorizes you to lie on your renewal application, but the stars have to align. You have to get lucky with your birthday when your birthday renewal is, and just don't miss that opportunity if you've got it. All right. During any board investigation, keep your license renewed. I got a call this past week. The lawyer was asking me what can we do? The doctor was being investigated by the board, had let the license lapse, and now the board's only form of punishment, the only sanction possible, is revoking the doctor's inchoate right to renew the license. So where you might have had an admonishment, a fine, now you've got what in shorthand is a revocation that's going to the National Practitioner Data Bank. So you might be in Florida, you might be ready to retire or something. For whatever reason, if you have an open investigation and you decide you don't want to renew your Massachusetts license, there can be serious consequences to that that go beyond you're just not you're letting that license your license lapse. You could end up with a revocation on your record. I always consider self-reporting. If you've got some bad news for the board, I'm not saying do it, but discuss it with a lawyer. Might make sense to report it yourself. Same thing with self-remediation. Even when there's a case pending before the board, discuss it with your lawyer. There's more than a few physicians I've sent to courses like managing workplace conflict that physician health services sponsors. It's become a very common accusation to be being a disruptive physician. So there's self-remediation things that strategies that often make sense. If it's inevitable that you are going to be reported by a hospital or an employer to the board through this through the board's healthcare facility disciplinary report, it's some that the narrative in that report, the basis code in that report, it's conceivably negotiable. All right. Something that a report to the board, it could start out harsh, it could start out neutral. That's a negotiation. There's some basis codes that set off alarms, and there's some that don't. Right. Again, I'll repeat, at the start of employment, ensure that your access to patient records is going to continue when you're no longer working there, and I'll repeat again, make sure your mailing address is current at the board. I'm gonna stop there for questions because I don't want to run. I don't want to run over.
Great. Well, we'll take a few minutes for questions for the counselor. We have our first question today was actually about retirement in the board, and if it was advisable to contact the board about your impending retirement, and whether there was any forms or process about doing so. Given your earlier statements, I wonder if that makes any sense at all. What are your thoughts about that?
Yeah, well, I mean, again, if you have an open complaint at the board, they won't let you retire in an easy, harmless way. If you have an open complaint, they'll let you retire by their regulation will allow you to retire, but you have to give up every license you have in every state and promise that you're never going to apply for a medical license anywhere ever again.
Good. Question from Joyce Baker.
When you mentioned if they call you, don't answer the phone, don't talk to the representative. How do you do that gracefully when they say this is the board of so-so of the Board of Medicine calling about so-and-so? How do you do not have a conversation with them?
Well, you find out who you're, what I would do is I would tell them that you'll get back to them and then call a lawyer. Just don't have the conversation right then. You can ask what it's about. That's okay. But don't answer any questions. Just say you'll be happy to get back to them, and then it's your lawyer who will get back to them. Don't worry about being rude. Somebody will get back to them. I mean, they're used to it. They're not going to hear you say, "Oh, she doesn't want to talk to me, so we're done. The investigation's over. We're going to bring charges." I'll get back to you, or somebody else will get back to you. I can't talk to you now. This isn't a good time. Somebody will get a lawyer involved, and the lawyer will get back to them.
Investigators are well used to the social norm of reciprocity, getting them a lot of information due to the natural reflex to want to engage and answer questions. But this is certainly a time to, I think, follow our good counselor's advice. There was one question in the box about how long we should be retaining our medical records, given the that there's no statute of limitations on action by the board.
That's a really good question. I have not encountered that. There's specific rules about how long you need to keep your medical records, since it's easier and easier now, because they're the more electronic they are, they're not going to take up file space. That's a very, very tough question. And I don't want to shoot from the hip on that.
Well, if you have further thoughts about it at a later time and want to notify us, we can certainly distribute to participants when we do that.
Also, Andrew, when Jim was in the system here, he used to talk about a general approach using 10 years, which got you past most of the issues of liability, repose, and so forth. I went further and recommended that if you're going to stop completely, you boil the case down to one page or one paragraph and keep that in your files forever if you're using paper charts. And that way you can refresh your memory about the case, even if it's 10 years later. But the 10 years was a nice round number. I mean,
the problem is, what reclaim memory of, from, 15, 20 years ago of, well, the doctor did this to me, and that, will your record help you? It's, you had, you don't have the record, you're naked. I mean, I had a doctor who received a complaint. He's pretty much retired now. He had received a complaint from a patient from his training program. So it was about it was probably about 45 years since he had seen this patient in the training program. The solution in that case was to refer the entire matter to the training program, which was, at a major university, and they've got lawyers. They're still there, and he was working for them, and let them defend it. But there's stuff that pops up after 45 years. You did this wrong thing. You abused me. You mentally abused me.
Why don't we take one last question from Michael Hanau?
I'm sorry, Bobby. I think you and I both raised our hands simultaneously, but I guess in any case, I have two questions, and perhaps you could choose whichever is most salient or answerable. One is a two-part question. How did we get into this mess as an industry, and how do we get out, where there's this regulatory board that has so much power and caprice, and from a systems standpoint would seem to drive people out of the prospect of practicing or embarking on a career in our noble field. But the other question is a bit more specific, which is I see that the board will, when a type 1 case is initiated, will say voluntarily surrender your license for the duration of the investigation. And so two colleagues of mine have done that, developed clinical depression, suicidality, and bankrupted during the investigation. One did not get their license back, and one did. I know of another case. I won't say how I know of it, but the physician said, no, I'm not going to surrender my license, and she continued to practice. And the investigation went on, and it's a years-long process, and I guess it's still ongoing. But she's practicing. She holds licenses in multiple fields and multiple states, and she continues to pay her mortgage. So I'm wondering, in terms of like being a good doobie and versus scorched earth, how does that map on to the question of paying the mortgage and retaining our license or not?
Well, if you receive a request from the board to voluntarily agree not to practice, I think that's probably what they were looking for. It's called a VAMP, and they want you to sign this in connection with an open complaint. You go to a lawyer and the lawyer's going to try to find, well, what does the board have that they want you to, that's justifying this request? And it's often the case that you just give the board the other side of the story, and the board backs off. I mean, you've got to, or you have to call the board's bluff, and because their default position is, if you don't sign the voluntary agreement not to practice, we're going to summarily suspend the license, which is the suspension followed by the hearing, and that's taking a wrecking ball to your career, because you've got to report the summary suspension to all your insurers, your employees. I mean, you can come back from a summary suspension, but it's hard. I mean, you're describing a few different cases. Each, it is common enough to be able to respond to the board with assuring information that takes the board away from this, oh, you need to voluntarily agree to not to practice while this complaint is pending. How did we get to this point with the board? I mean, it's multifactorial, right? One of the problems, I think, is that the board tends to hire former criminal prosecutors, and that's their orientation. I mean, the enforcement staff is comprised almost completely of former criminal prosecutors. You have board members who are part-time, and they're you say, well, why do you have board members? You have board members so that they will exercise some discretion, so they won't rubber stamp everything that the prosecutors want to do. We've gone through, the pendulum has swung back and forth with where the Supreme Judicial Court sometimes restrains the board, sometimes lets the board go further. I mean, that's over the past 30 years, that's gone 30, 40 years, that's gone back and forth. Right now we're in a period of I'd say the SJC giving the board more leeway. Politically, it's very, very hard to, nobody is going to stand up for quote unquote bad doctors. It's just you're not going to find that kind of support in the legislature. Why
don't we take one last question from Dr. Gutile, and we'll wrap and move on to our next presentation. Tom, you got to unmute.
Andrew, thanks for a very thoughtful discussion of this issue. I have noted in the chat, and I had a question from many, many years, the board's history of dealing with prosecutors as their attorneys leaves them often in the situation of assuming guilty until proven innocent, rather than vice versa. Has that also been your experience?
I think it's there seems to be some tunnel vision, and the enforcement unit is just they're very prosecution oriented,
right?
For years, for years, we can blame, believe it or not, Ralph Nader for years and Public Citizen had this ranking of the 50 state boards, and they took the number of actions they took the number of serious disciplinary actions as the numerator, and the denominator was the number of licensed physicians in the state. And they did that computation for every state and ranked the boards from year to year. Well, this is the number one place that disciplines the most physicians is the quote unquote safest place to practice, right? And number 50 is the most unsafe. And the Federation of State Medical Boards fought with them for years, and finally they stopped doing that, and there've been some variations on it since. But it's this idea of the rate of discipline is indicative of how safe you are, that carries through to today. And I mean, it is so, you know, I mean, I put my MPH hat on, and that is so preposterous a measure. It's so nonsensical. I mean, even you know, looking at, you know, so 1 year, you know, the tiniest state, Vermont, has 4 disciplinary actions, and the next year they have 5, and they changed 20 in the ranking. I mean, it just that's one issue. The other is, are hospitals safer in Massachusetts than Arkansas? Well, and there are other ways to measure than how many physicians are disciplined. So, so I mean, that's been that's been this crazy measure of patient safety. It's a masquerade, and it's been very hard to get away from that. Discipline lots of physicians, and everybody's going to be safer.
Well, let's close on that hopeful, optimistic note. Michael, thank you for your question. It's a good transition to our next presentation. So, but first,
right, thank you.
Councilor Hyams, thank you so much for presenting today. We appreciate your time and sharing your experience and guidance.